Good morning, everyone, and thank you for joining us today for this webinar from Cornerstone Planning Team. My name is Ed Grant, and I'm joined by my colleagues Emmeline Lambert and Isabella Buono. The subject today is a practical guide for giving evidence at planning inquiries, and this could easily have been a half-day course, but we aim over the next hour to give practical advice to the 450 or so of you who have joined us this morning. Now, two bits of housekeeping before we get started. First, thank you very much indeed to all of you who have submitted questions in advance. There have been over 80, I think, of these, and we've tried to address a lot of them, or as many as we can, in the ground that we cover. The effect of that is that it may leave us with limited or no time for Q&A at the end, but do send any further questions using the Q&A facility, and if there is time at the end to answer any of those questions, we will do. Second bit of housekeeping, the slides that you'll see during the webinar will be available from the Cornerstone website shortly after we finish this morning, and also there'll be a recording of the webinar which will also be available on the website probably early next week. Now, on the menu this morning, we have 6 topics, and just taking you through those, chapter 1 of the practical guide this morning is the duties and responsibilities of expert witnesses. Chapter 2, effective proof writing. Chapter 3, the structure of oral evidence. Chapter 4, the do's and don'ts of oral evidence. And if anybody thinks that the use of apostrophes on the slide there is wrong, Emmeline insists it's correct. Chapter 5, the impact of Rosewell on giving evidence. And finally, Chapter 6, A Brave New World, remote inquiries. So that's 6 chapters in 60 minutes, and to start us off with chapter 1, Emmeline.
Thank you, Ed, and good morning, everyone. This chapter of the webinar is relevant to expert witnesses and applies throughout your appointment as an expert, from assessing instructions to your written evidence to your oral evidence. It's important to understand that when you're giving evidence to a planning inquiry on matters consistent with your area of expertise, whether that's planning, heritage, transport, landscaping, or any other number of technical areas that crop up in the determination of planning matters, you are giving evidence as an expert witness. So who is an expert? The Planning Inspectorate in their appeal guidance, the latest edition, March 2020, explains at Annex O that expert evidence is evidence that is given by a person who is qualified by training and experience in a particular subject or subjects to express an opinion. First slide, please, Isabella. The primary duty of an expert witness giving evidence to a planning inquiry is to the inquiry itself. The very purpose of the expert's involvement is to enable the inspector or the Secretary of State to make an informed decision. This duty to the inquiry overrides any duty which is owed to the party for whom you are appearing. This basic and long-standing principle is also included in the PIN's guidance at Annex O. This duty is entirely consistent with your obligations as a professional. And for those of you who are members of a professional body, it will be consistent with the code of conduct published by your professional body. The RTPI, for example, requires members to subscribe to 5 core principles: competence, honesty and integrity, independent professional judgment, due care and diligence, equality and respect, and professional behaviour. REBA similarly includes principles of integrity and competence. And as to independent professional judgment, the RTPI code emphasises that members firstly must exercise fearlessly and impartially their independent professional judgment to the best of their skill and understanding, and secondly must not make or subscribe to any statements or reports which are contrary to their own bona fide held professional opinions, nor knowingly enter into any contract or agreement that requires them to do so. Again, the REBA Code of Conduct sets out duties including acting with impartiality and objectivity at all times in professional activities, and being honest and truthful, and not allowing themselves to be improperly influenced by others. Whatever professional body you belong to, the duty to the inquiry to provide evidence which represents your honestly held and independent professional judgment is paramount. This means that before you agree to provide expert evidence for a particular party, you must be satisfied that your professional judgments will support that party's case, all of that party's case. Make sure you understand all elements of your client's case before agreeing to the job. Consider everything you can before accepting instructions, including all arguments you are being asked to advance. It's difficult to imagine anything more damaging to the credibility of an expert witness than the revelation during cross-examination at a public inquiry that the witness was happy to accept the brief before visiting the site, or in the COVID-19 world, at least virtually visiting the site, or before receiving the relevant documentation. A witness who starts with the answer that their client wants and then works backwards will often come unstuck when under scrutiny. In 2014, whilst President of the Supreme Court, Lord Neuberger gave a speech to an annual expert witness conference regarding the working backwards approach, which was discussed in his speech in the context of the work of the great philosopher Karl Popper. Neuberger said this about Popper: "One of his two great contributions was his insight into the way in which scientific discoveries are made. The popular view is that a research scientist investigating a problem will start with the currently available information and knowledge and work through a series of logical steps to arrive at an answer to the problem. Far from it," said Popper. "The scientist conceives of a possible answer and then works backwards to justify it, if he can. That makes sense when you think about it. Remember those puzzles we had as children? There are 6 entrances to the maze and only one of them leads to the center. The natural and instinctive thing to do is to start with one entrance and then, when and if it doesn't work, move on to the next and so on until you find the right entrance. The scientist who has the bright idea immediately has a vested interest in proving it's right. And when he thinks he has proved it, he has an even more vested interest in defending the idea and his proof. That's human nature. However, when an expert is instructed to act for a client, I suspect that he may very well adopt the Popper approach and start with what he hopes or expects will be his final position, and then works backwards to prove that it is right. And so, looking at the final bullet point on that slide, don't start with what your client wants and then justify it. Moving on from Karl Popper, Isabella, next slide, thank you. The courts have provided very helpful guidance as to good practice for expert witnesses in properly discharging their duties and responsibilities, notably by Mr. Justice Creswell in the 1993 shipping case known as the Icarian Reefer. Firstly, the expert evidence should be the independent product of the expert, uninfluenced as to form or content by the demands of litigation. Secondly, the expert should provide independent assistance by way of objective, unbiased opinion in relation to matters within his expertise. Thirdly, the expert should state the facts or assumptions on which his opinion is based and should not omit to consider material facts which could detract from his conclusion. Fourthly, the expert should make clear when a particular question or issue falls outside his expertise. Fifthly, if the opinion stated by the expert is provisional only, for example, because insufficient data is available, the expert should say so. Sixthly, if after an exchange of reports, the expert changes his view on a material matter, having read the other side's expert report, or for any other reason, this change of view should be communicated as soon as possible. And lastly, where expert evidence refers to photographs, plans, calculations, analysis, measurements, survey reports, or other similar documents, these should be provided at the same time as the exchange of reports. The duties have been referred to on numerous occasions, most recently followed in 2018 in a case called Armstrong and ERS Syndicate Management. In 2000, in a construction case, Anglo Group PLC and Winter Brown & Co., the court restated the Creswell principles and added an important further point, namely that an expert witness should cooperate with the expert of the other party or parties in attempting to narrow the technical issues in dispute at the earliest possible stage of the procedure and to eliminate or place in context any peripheral issues. Inspectors like to see this cooperation between experts, and a helpful way of presenting a joint position on an expert topic is through a separate statement of common ground. Relevant to this, Laura from Winchester City Council has asked if planning officers should be familiar with the CPR rules for expert witnesses. In broad terms, the CPR does reflect the Creswell principles, but it is particular to giving evidence in civil courts. So planning officers must be familiar with those rules if giving evidence in civil proceedings, and of course with criminal procedure rules on experts if giving evidence in a criminal case. Next slide, please. Thank you, Isabella. For local planning authority witnesses, another area to be aware of is in not compromising your duties when it comes to defending the position of the council on a member overturn. The RTPI guidance makes clear in a practice advice note dated September 2018 that if you are putting forward a view supporting the members, but it is not your own professional view, then to make that clear in your oral and written evidence. But actually, if you do not agree with the member decision, you are not likely to be a helpful witness, and you should be clear about your own professional opinion at an early stage so that this either does not come as a surprise to your team or that the LPA is not disadvantaged. There may be another team member who does support the member decision, or the council may be advised to appoint an external consultant. Next slide, please, Isabella. Experts will not, of course, always be right. If experts did not agree with one another, the planning process would be a very simple affair indeed. In fact, we can probably all think of matters throughout history where there has been an apparent consensus of scientific wisdom, only for them all to be proved wrong by future generations. In an inquiry environment, it is routine for two well-respected experts with honestly held opinions in the same field to take dramatically different positions. The challenge, therefore, for the expert witness at a planning inquiry is to persuade the inspector that your opinion is the one that should be trusted and relied upon, rather than the opinion of your counterpart expert witness. That challenge, to persuade the inspector that you are right, is not just about what you are saying, but how it is said. A good witness will be able to explain his evidence on sometimes very complex and technical issues in a way which can be clearly understood by those without his or her expertise. The good expert witness will be able to demonstrate a clearly navigated path from the entrance of the maze to the centre of the maze. And on that note, I now hand over to Isabella for the next chapter in this webinar about effective proofs of evidence.
Thank you, Emmeline. And before starting my top tips on effective proof writing, I just wanted to remind everyone that the Planning Inspectorate publishes procedural guides on both planning appeals and planning enforcement, each of which include useful sections on proofs of evidence. Hopefully we'll include links to those guides alongside the slides to this presentation on our website for ease of reference for anyone who hasn't read those yet and would like to look them up. I'm going to include the key points from those guides within my part of the presentation. There are two key parts to effective proof writing, presentation and content. We had a question from Joe Perkins as to what's more important, presentation or content, and my answer is that both are important. Good content can be diminished by poor presentation, but of course, poor content cannot be made good by really good presentation. Presentation's an easy one to get right though, but it can make the biggest difference. And some of these points might seem basic or obvious, but they're really things that you should make sure you get right from the outset. So I have 3 top tips for presentation, and they are: firstly, make your proof easy to read. Use size 12 font, use double or 1.5 spacing, and use regular margins. Secondly, make your proof easy to navigate. The barristers, the inspector, and the other experts will all want to refer to specific points that you make in your proof in specific places, so make sure you number both your pages and your paragraphs. Also, set out a clear roadmap for how your proof is structured. Have a contents page, use headings, subheadings, and tell the reader where you're going. If you've got 3 points to make, say so, and then go through each of them in turn. Third, cross-reference. If a statement is taken from or supported by a particular policy or piece of guidance or a map, for example, say so. Give the core document reference and the relevant page and paragraph number. Make it easy for the inspector to turn up the documents that help your case. Think of your proof as a guidebook from which the inspector can write their decision letter. The easier your proof is to follow, the more persuasive it will be. Related to that, and before I move on to my top tips for content, I just wanted to answer 2 questions that we'd been asked in advance. The first was sent in by 2 people separately, which was whether you should include illustrations or photos or plans in the main body of your proof. And my view is that if it's appropriate, yes, you should. It breaks up the text, makes it easier to read, and it can have a greater impact on the inspector than the inspector reading or listening to you and then having to pause, find the document, and then come back. If you do include an illustration, photo, or plan in the main body of your proof, you should give it a figure number so that it's easy for others to refer to. Remember, easy navigation and cross-referencing are key. The second question is one from Averil at Vale of Whitehorse District Council about whether in the present circumstances it's okay to provide links to documents given the difficulties we're all facing trying to print and manage hard copies at home. The procedural guide, which was published in March or updated most recently in March of this year, said that you shouldn't include hyperlinks in your proofs. And I think that's at least partly because websites can do change. So if you give a link in your proof now, when the inspector comes around to be writing his or her decision letter sometime in the future, it may be that that link no longer takes the inspector to the same place, or that the text might have changed. Therefore, it's important that you either download the document or save the web page as a PDF and then share that electronically if you're having difficulties with hard copies. So from presentation on to content, it's obviously difficult to give advice as to what you should include in the substance of your proof in the abstract, but there are 11 main building blocks here that you'll need to assemble in your proof. Most of them should be relevant to everyone, but some of them may be particularly relevant to planners. My first building block was giving a full account of your experience and qualifications. Don't be too shy and don't undersell yourself. This is likely how you'll be introduced in evidence in chief, so it's important you set yourself up on the strongest possible footing. It's your opportunity to tell the inspector that you really know what you're talking about and that he or she should trust your judgment. Second, give a site description. If the site description has been agreed in full in the statement of common ground, then you don't need to set it out all again in your proof, just refer to the relevant paragraph or paragraph numbers in the statement of common ground. We were asked quite a few questions in advance about how to reduce the length of proofs, and that's a good general tip. If something's agreed in the statement of common ground, you don't need to set it out all again in your proof, just make the appropriate reference. In fact, the procedural guides say that you really shouldn't be dealing with matters in your proof which are agreed. Your proof is really meant to be focused on what's still in dispute between the parties. Third, set out the planning and enforcement history. In an ideal world, again, this is something that would be dealt with in the statement of common ground. We were asked a question by Natalie at Braintree about how much background is needed in a complicated enforcement case. I think the answer is to include only as much of the history as is relevant to the particular decision that's being made. If it's relevant, it needs to go in. If it's not relevant to what's being decided, it doesn't. Sorry if that's a little bit like saying how long's a piece of string. The fourth building block is the description of the proposal. That shouldn't be too controversial. Fifth, set out the test for determination. For planning decisions, of course, that's from section 38.6 of the Planning and Compulsory Purchase Act, which is that the decision must be in accordance with the development plan unless material considerations indicate otherwise. Then you can set out the relevant adopted development plan policies and make sure you list all of those policies which are relevant to the case, even those which undermine your case, and even those which you don't consider to be conflicted. The statutory test requires you to look at the development plan as a whole. Also, in relation to development plan policies, remember that weight is to be determined by reference to paragraph 213 of the NPPF, according to the degree of consistency with the framework. Seventh, list the relevant emerging plan policies. Remember, they don't count as part of the adopted development plan, but they can be material planning considerations. You'll need to reach a judgment as to how much weight you think should be afforded to each of those policies, and that might vary policy by policy. You'll need to make reference there to paragraph 48 of the MPPF, which says you need to look at the stage of preparation of the plan, the extent of unresolved objections, and the consistency with the framework. Given that some policies within an emerging plan might generate lots of objections and others might generate none at all, then that's of course an example in which different policies might be afforded different weight. 8th is your analysis of whether the proposal is consistent with the development plan as a whole. There was a new judgment handed down not that long ago in April in the case of Corbett, which makes clear that even if there's a breach of a really restrictive policy, that doesn't necessarily mean that there's a conflict with the development plan as a whole. You need to consider the language and importance of each policy, which you say have been breached, and the extent of that breach to reach an overall judgment on this. 9th is your analysis of the other material considerations. We were asked by Chris at Wokingham to give some guidance as to what material means in this context. Put simply, material means relevant to the decision that's being made, and that would cover a broad range of matters, including, as I just mentioned, emerging plan policies and also the framework, but it excludes purely private interests such as the impact of a development on the value of a neighbouring property or the loss of a view. The PPG on determining planning applications provides some clear and useful guidance on this. 10th is the balancing exercise. The top tip there is to make sure that your planning balance is balanced. Make sure you go through all the relevant benefits and harms, even if you think they're straightforwardly outweighed. And then finally, you'll want to finish with a summary and conclusion. The procedural guide also requires a summary proof if your main proof of evidence is over 1,500 words. Your summary is likely what you'll be asked to read out in evidence in chief, so it's important that you give careful thought about how best to capture evidence. Don't underestimate how long that actually takes and leave it to the last minute. The procedural guide also provides suggested text for your endorsement of the accuracy of your evidence, and that's something that fits in with the duties that Emmeline was talking through a moment ago. And that says that you should say, the evidence which I have prepared and provided for this appeal, and then give the reference, is true and has been prepared and is given in accordance with the guidance of my professional institution. I confirm that the opinions expressed are my true and professional opinions. Preparing for an inquiry requires everyone to come together as a team, and the proofs of the various experts will be separate and shouldn't overlap. A landscape expert shouldn't be giving her own separate heritage evidence when there's a heritage expert. But you will need to be aware of the other experts' evidence and hopefully situate your proof within the context of those. So at the very least, you need to make sure you read the other proofs of evidence being given by experts on your team before you sign off on your own. Hopefully it would be useful to get a barrister involved at the earliest possible stage, because part of our job is making sure all of the evidence comes together in the most effective way. Related to that, in terms of when to start thinking about your proof, Mark at Mole Valley helpfully sent in his observation that planning officers should have their proof in mind when they write their officer's report. I definitely agree with that. If you haven't set something out in your report, which you later rely on in your proof, you're going to be cross-examined on it and will likely find it difficult to defend. And next, I'm going to go through chapter 3, which is on the structure of oral evidence. So your oral evidence will fall into 3 or possibly 4 sections: evidence in chief, cross-examination, re-examination, and possibly inspector's questions. I'm going to go through each of those in turn. Starting with examination in chief. This is what will come first, and it's the section of your evidence when you'll be asked questions by your team's barrister. There is nothing that he or she should ask which should come as a surprise here. Strictly speaking, a barrister examining evidence in chief cannot ask a leading question. What is a leading question, you might ask? It's a question that suggests an answer. So, what colour is that car is not a leading question. Is that car blue is a leading question because it suggests the answer. I say strictly speaking, you shouldn't lead, because as a matter of convention and common sense, the barrister can ask leading questions on matters which are entirely uncontroversial. As the most obvious example, nobody would criticise the barrister or advocate for asking, "Is your name Joe Bloggs?" And leading questions on non-controversial matters like that obviously moves things along. Your evidence in chief is likely to take the following pattern with three main steps. The first will be to introduce your qualifications and experience and possibly cover how you came to be involved in the case. Some of this is likely to take the form of leading questions. If your advocate gives you free rein to detail your qualifications and experience, be confident and self-assured. As I said earlier, don't undersell yourself. Remember, you are persuading the inspector that you are someone who really knows your stuff and that your opinions can be trusted. Secondly, your proof of evidence will likely be taken as read, and assuming your proof exceeds 1,500 words, as I already mentioned, you'll have produced a summary proof of evidence. You may then be asked, after introducing yourself, to read out your summary proof. Occasionally, this will be dispensed with if the inspector considers it unnecessary, for example, when there are no members of the public in attendance. The next part will be some supplementary questions. This is really the most important part of your evidence in chief. It's likely to cover, first, clarifications to your proof, perhaps by cross-references to your appendices or to core documents. Secondly, your response to points made by the opposing team's expert in their proof. And thirdly, your response to points made by the opposing team's expert during their oral evidence, if they have given evidence before you. We were asked by Robert at Bexley if barristers can coach or advise witnesses. And coaching isn't something that we're allowed to do, in the sense that we can't tell you the answers to give or not to give, but we can give you an idea of the questions we're going to ask in advance. And it's useful for us to know what the answers to your questions are. Your answers might make us change the questions that we're going to ask, or make us think about how best to neutralise an unhelpful point. But the fact that we don't like your answer doesn't mean that we can tell you not to give it. You're the expert and the evidence is yours to give. Next will be cross-examination. And in cross-examination, the opposing advocate is allowed to ask you leading questions on all matters. It's helpful to understand if you think what the cross-examining advocate is trying to achieve. And there are four main goals that they'll be trying to pursue in cross-examination. The first is to identify where you are in agreement with the other side's experts, usually by reference to the statement of common ground. Secondly, they'll be trying to identify weaknesses in your analysis. They'll be thinking about what were the limitations of your brief, what underlying assumptions you made, which might be flawed, and what material matters you might have overlooked or ignored, and to what extent your methodology failed to follow any published guidance, for example, HE guidance in relation to heritage matters. Thirdly, they'll be trying to undermine your credibility. They'll be thinking about what were the circumstances in which you agreed to give evidence on your client's behalf. Has your analysis identified or acknowledged matters which might not assist your client's case? And is your evidence balanced overall? Fourthly, they'll be trying to put to you their opposing case. Although there is a less strict requirement to do this than in, for example, civil proceedings, the advocate will usually be trying to emphasise the strengths of their own case. Whether you feel cross-examination has gone well or badly or somewhere in between, you're likely to feel enormously relieved when you hear the magic words, "No more questions." However, it's crucial that you don't take that time to relax or, worse still, switch off. You're not finished yet. Re-examination provides an opportunity for the advocate on your team to ask you further questions, subject to two limitations. The first is that re-examination must arise out of questions or answers in cross-examination. An advocate who uses re-examination to put questions which he or she has forgotten to put in the examination in chief will be swiftly rebuked. A good advocate will include a prompt not as to the answer but as to context to help you and the inspector. So, for example, you're asked in cross-examination questions about the weight to be given to policy AA1, and then followed by the question in re-examination. The second limitation is that questions in re-examination must be non-leading questions. Again, that's what colour was that car, rather than is that car blue. You will sometimes find that you will not be re-examined at all, but if you are re-examined, concentrate hard. The advocate is trying to recover ground which might have been lost and perhaps gain some ground. It may be, for example, that you gave an answer but were not able to qualify it, and re-examination would then give you the opportunity to do that. It may also be that in cross-examination you were taken to one part of a document which helps the other side's case, but you weren't taken to another part of that same document which helps your case, and in re-examination your team's barrister might help you to make that point. It's important not to try and overthink what is the answer that your advocate is looking for. Just answer the question simply and you'll find that that's usually the exact answer that they were hoping you would give. And fourthly and finally, inspectors are entitled to ask questions to witnesses. Some inspectors are more interventionist than others. The inspector can ask questions during examination by the advocates. Usually, however, the inspector will wait to see if any questions that they have been left unasked and will answer them either before or after re-examination. Questions from the inspector are often the best way of trying to work out which direction the inspector is leaning. And finally, we were asked a question by Kelly at Guildford about how best to answer inspectors' questions. Ed is going to set out some golden rules for answering questions in a moment, all of which apply to inspectors' questions. But my top tip for inspectors' questions specifically is that it's important as a witness not to allow yourself to be lulled into agreement just because the question is coming from the inspector rather than from the opposing team's advocate. As always, agree if you agree, but disagree if you disagree. And now I'll pass back over to Ed, who will be talking through the do's and don'ts of evidence.
Thanks, Isabella. So chapter 4, the do's and don'ts of oral evidence. I've yet to hear anyone at a planning inquiry say at the conclusion of a witness's evidence, the problem that witness had is that he or she had prepared too much. If there's one golden key to giving evidence, it's preparation. And importantly, preparation, of course, breeds confidence. And there can be no worse feeling as an expert witness than knowing that you're about to be cross-examined and feeling unprepared. There are a number of straightforward measures that a witness can take to ensure that he or she is well prepared. Firstly, know your stuff. This means not only having a clear mind about your position and the paths that you have taken to reach your conclusions, but having a very clear understanding of where the expert on the other side disagrees with you and why they disagree. And I remember a case conference with a witness a couple of days before an inquiry was due to start. And as we began, it became immediately obvious that he hadn't yet read the proof by the witness on the other side. He thought he'd do it the night before. And I knew then that he would be a poor witness, and he was. Second, don't underestimate the time required to prepare properly. It will always take longer than you think. Third, ensure you have a case conference with your advocate between the exchange of proofs and the start of the inquiry, and preferably not the day before the inquiry. As Isabella said, your advocate can't coach you. In other words, can't tell you what you should be saying, but the advocate can, first of all, give you a very clear understanding of the questions that you're going to be asked in evidence in chief, and secondly, discuss with you the issues that are likely to be raised in cross-examination. And in answer to a question from Tracy at South Oxfordshire District Council, there should be no surprises at all in examination in chief, and rarely a surprise in cross-examination. Finally, this, whether you prefer to work from hard copy documents or electronically, ensure that you know your way around the papers. So if you're working from hard copies, use post-its, marker pens, underline, or their electronic equivalents if you're working electronically, to make life easier and smoother when you're navigating your way around the documents during your evidence. And your barrister should really give you a clear list in advance of which documents you'll be taken to in examination in chief. And that'll help you, and it'll help the process be much smoother. Now, what about the final countdown? Before we go on to the next slide, the final countdown, which is the minutes before your evidence is due to begin. And those are really important to use that time wisely. So how can you do that? Well, if your evidence is due to begin at the start of the day or after a natural break in the day, you'll have had time in the break to get yourself ready and set up at the table. But if not, then ensure with your advocate that the advocate will make sure that the inspector gives you a few minutes to set yourself up, because it's not a calming experience as a witness to be organising yourself at the witness table whilst all eyes are on you, impatiently watching you get yourself arranged. So crucial, organise yourself at the table. And that means don't sit there with a sky-high pile of papers or a box of papers, but know where your proof and appendices are at the table. Know where the opposing experts' proof and appendices are. Know where the relevant policy documents are, the NBPF, for example. So know your way around the table. And even if it's a remote inquiry, then still know your way around your table if you're using hard copy documents, and know your way around the electronic files if you're using electronic documents. Always, by the way, ensure you've got a full glass of water at the table, because you're likely to become thirsty, but also sometimes a well-timed sip can buy you a few seconds of extra thinking time when you most need it. And now on to the next slide, please, Isabella. We've set out here 18 do's and don'ts, or golden rules of oral evidence. And many of these things might sound obvious, but they're easily forgotten in the heat of the moment. And we set out 18 things to remember. First, keep your voice up. It's remarkable how often a witness has to be reminded about this during the evidence. And failing to keep your voice up can be damaging for at least 4 reasons. First, your evidence won't be heard properly. Second, it makes you appear to be lacking in confidence. Third, it will almost inevitably irritate the inspector. And fourth, it will distract from the evidence that you're trying to convey. Next, speak slowly. The inspector will be making notes of your evidence, so follow his or her pen and pace yourself according to the pen. If the inspector's not writing anything at all down, that's not often a good sign. But anyway, speak slowly, because it not only enables everybody to follow what you're saying, including the inspector, but it also enables you to say exactly what you mean. Next, pause before you answer. Just take a few seconds. It'll help you to formulate what you want to say. And so long as you don't overdo it, you won't come across as uncertain, but you will come across as careful and measured. Address your answer to the inspector. It's an unnatural thing to do because the question's coming from the advocate, but try to do it, and nobody would ever regard that as a discourtesy. Next, if you didn't hear the question, ask for it to be repeated. If you didn't understand the question, ask for it to be repeated. And if the inspector then says to the advocate, as they sometimes do, can you rephrase the question, or can you shorten the question, or can you simplify the question, then that should reassure you that the problem is with the question. If you need time to answer the question properly, for example, because you'd like to refer to a document first, then say so. The inspector will almost certainly understand. If you don't know the answer, then again, just say so, whether that means you saying, I don't know, or I don't know without checking with a particular document, or I don't remember, or that's outside my expertise, but never guess at an answer. So in ordinary life, if somebody asked you what's the capital of Ecuador, and you had no idea, you just say you don't know, but for some reason, when people are giving evidence, whether in court or at an inquiry, they feel like they have to have a go, but don't, just say you don't know. And next, don't be afraid to agree with the cross-examiner if you agree with what is being put to you. And here's a good example to illustrate this. I was once cross-examining a transport witness at an inquiry in Wiltshire. The first question I asked him was, do you agree that the closer somebody lives to a bus stop, the more likely they are to use the bus? Now that was a question which had only one answer. It didn't, of course, mean they will use the bus, but under no circumstances was that witness prepared to agree with the proposition. And he almost certainly, in my view, lost significant credibility in the eyes of the inspector. Next, golden rule here, answer the question. That also, of course, means listen to the question. A failure to answer the question you're being asked is the surest way to lose the trust of the inspector. And what you don't want to do is to give the advocate the opportunity to say to you with full barristerial pomp, well, that's all very interesting, but can I have an answer to the question, please? Or what part of the question don't you understand, and I'll re-ask it? Or worse still, are you asking us to note that you're not willing to answer the question? If you'd like to offer a qualification to your answer, then just say, my answer is yes, but can I qualify that, please? The inspector, or failing that, your advocate, will ensure that you do have the opportunity to qualify it. And just pausing there to answer a question that came from Leslie, is the best strategy to say just enough, is the question. And the answer to this is that whilst it's important to be precise and to be relevant, a witness should always avoid appearing to be evasive or guarded. So what really matters is just giving a clear answer to the question that you're being asked. Next on our list, don't venture outside your expertise. So be wary of cross-examining advocates looking to take you outside your comfort zone. Just say, that's not within my expertise. And sometimes a persistent advocate will try again and say, well, just try and help us if you can. And if they do, just repeat your answer, that's not within my expertise. Next, keep your answers succinct wherever possible. Don't ramble, and don't feel it's your responsibility to fill a moment's silence. Adam from Tewkesbury asks, is it better to say more or less in cross-examination? And the answer to that, again, is to say what's relevant. That doesn't matter whether it's a one-word answer or an answer that takes minutes. Just give the answer that is relevant to the question that you're being asked. Next, avoid imprecise language and also avoid emotive language. I vociferously disagree, for example, is no more effective than just saying, I disagree. I once cross-examined a witness who, in answer to a proposition I put, said that he violently disagreed with the proposition, although I'd like to think that wasn't what he actually meant. Next, never interrupt the advocate and never ever interrupt the inspector, because there's only ever one downside to that. Don't be rude or discourteous to the advocate, however much you feel you're being provoked. So I know of one very experienced expert witness who has a reputation for being routinely rude to the cross-examining advocate from the outset. He might feel he's impressing his client, but he probably isn't. He certainly isn't helping his client, and he won't be helping the inspector, and far from it. Second last of our 18 do's and don'ts. Don't try to be funny when you're giving your evidence, because it just almost never works in an inquiry environment. And finally, keep your poise. Try not to allow the opposing advocate to unsettle you with questions or comments like, are you seriously telling this inspector that? It's an attempt to unsettle you. Just keep calm and keep your poise. And we had a question from Senjuti at Wokingham, who said, how should a witness remain non-committal when facing a tricky question from an aggressive barrister? And the answer is really covered, isn't it, by a series of these 18 points. Answer the question, don't guess, don't venture outside your expertise. If you need further time to consider the point, then say so. And remember too that most barristers are firm but polite. Most don't have an aggressive style. It's unappealing, it's often unproductive, and it's not a popular style with inspectors. Before moving on to the next chapter in this webinar, which will be chapter 5, a last word on giving evidence. If you have not given evidence before, do everything you can to ensure that the first inquiry where you give evidence is not the first time you see evidence given at an inquiry. So try to attend an inquiry to observe. See if there are opportunities to take part in a mock inquiry, because without question, familiarity with the process will by itself put you at ease. And we're going to move on now to Emmeline and chapter 5 in the webinar, who's going to tell us about the post-Rosewell environment.
Thank you, Ed. Yes, this part of the webinar looks at giving effective evidence in the Rosewell world. In December 2018, a report was published, independent but commissioned by the government, called the Independent Review of Planning Appeal Inquiries. The chair of the review was Bridget Rosewell, and as we all know, it's now well known as the Rosewell Review. The review itself was concerned with Section 78 appeals and called-in applications that are the subject of an inquiry, so didn't concern enforcement or listed building consent inquiries, nor appeals determined by written representations or hearings. The foreword by Bridget Rosewell set out the aim. My review of the way in which inquiries are planned and managed has focused on how to improve in practical ways the operation of the appeal process for those planning appeals where an inquiry is required or relevant. I believe that we can halve the length of time from lodging an appeal to a decision to about 6 months. The complaints about the time taken for appeals to be heard was one of the issues investigated by the Rosewell report, which concluded that there are a range of factors that underpin the current problems and delays, including, as we see there, outdated administrative processes and poor IT, a backloaded process, delays underpinned by fear of judicial review, and also the restricted availability of suitable inspectors to conduct the inquiries. A number of the recommendations were aimed at speeding up the administrative processes at the inspectorate. Thank you, Isabella. The review made 22 recommendations, and they were centred around 3 main themes. Firstly, earlier engagement by all parties. Secondly, greater certainty about timescales. And thirdly, harnessing technology to improve efficiency and transparency. Next slide, please. Within earlier engagement by all parties, the following was suggested. A, identification of the inspector who will conduct the inquiry at the outset of the process. Initial pre-inquiry engagement between the inspector and the parties involved no later than week 7 after the start letter. And lastly, case management directions issued by the inspector to the parties about the final stages of preparation and setting out how evidence will be examined at the inquiry within 8 weeks of the start letter. Following a pilot in February 2019 and widespread application of the recommendations by PINS from March that year, in May of the same year, the Planning Inspectorate published that they were making good progress in implementing the recommendations. And in September 2019, they published their updated action plan, setting out how the recommendations were being put into practice. But we saw inspectors embracing these recommendations well before September 2019. In March 2020, PINS updated their procedural guide for planning appeals. Annex H sets out that all Section 78 planning appeal inquiries are now conducted under the review's recommendations, save for those in the system that were arranged under the old bespoke arrangements. Inspectors have always had wide case management powers, including in relation to how evidence is heard. See Rule 15 of the Town and Country Planning Inquiries Procedure England rules. But in order to conduct inquiries under the recommendations, the appointed inspector is exercising greater case management power than before. A range of options is open to the inspector, but relevant to this webinar is that in terms of determining how evidence will be examined at the inquiry. Prior to COVID-19, there was a notable and conscious move towards less formal cross-examination and more roundtable discussions. Ed will talk more about what we are seeing happening post-COVID-19. But in the post-Rosewell non-COVID-19 world, we have identified 4 key points to note which impact on your performance in giving evidence as an expert witness. Next slide, please, Isabella. Thank you. These points have emerged as practical consequences of Rosewell. Firstly, there's no doubt at all that the process has speeded up, largely because of the speed with which PINS is issuing start letters, the reduced flexibility on date fixing for inquiries, and the ambition that inquiries commence within 13 to 16 weeks of the start letter. All of this means that your preparation needs to start early. You need to be having case conferences with your team, including your advocate, very early in the process. Time will fly, so the message is prepare early. Secondly, there is now a greater emphasis on dealing with evidence on a topic-by-topic approach. So, for example, landscape witnesses giving evidence consecutively before the inquiry moves on to the next topic. This was regarded by Rosewell as shortening the inquiry process by reducing repetition and allowing for more efficient programming of expert witnesses. This also means that the appellant won't have as much time as before to consider the evidence that's been given by the LPA. Thirdly, there's much more, in fact almost routine now, consideration given to which issues can be dealt with by a roundtable discussion rather than by the formal examination of witnesses. The result is an increasing frequency of hybrid inquiries. Formally, these are inquiries, but in practice, some of the inquiry is conducted as a hearing. These roundtable discussions are very much led by the inspector, who will usually publish in advance an agenda for the discussion. And we advise that if no agenda is published, the inspector should be encouraged to publish an agenda in order to assist witness preparation and to help the witness feel settled that they have an idea of what is coming up. As a witness, there are 4 points you should have at the forefront of your mind if your topic is to be dealt with by roundtable discussion. Firstly, ensure that your proof is comprehensive. You may find it even more difficult to offer further explanation of your arguments in a roundtable environment. You won't have your barrister asking you questions in chief to bring out points or to bring out rebuttal points. Secondly, be sure to consider with your team whether you serve a rebuttal after exchange of proofs. Rebuttals may be more important if your topic is to be dealt with by roundtable, as you may not have the latitude that you previously had to explain why you disagree with arguments put forward by the opposing expert in their proof. If it's in the rebuttal, your barrister can rely on that evidence served in closing submissions, even if there were no specific questions about it. Thirdly, if there is something at the roundtable discussion which you feel needs to be said, then in consultation with your advocate, make sure that you make your point, otherwise the opportunity may be gone. And fourthly, take careful notes of the evidence as it proceeds. This doesn't just help you deal with a point in rebuttal, but it also ensures that all points can be covered properly by the planning witness sweeping up and in the closing submissions. Rosewell encourages a more interventionist approach by inspectors during formal oral evidence. Inspectors will step in more often to prevent repetition or verbosity by an expert witness. Of course, there may be expert witnesses and many advocates who don't need an inspector to intervene, but if nothing else, this is a reminder to the expert witness to keep answers succinct and to the point. So what are the advantages and disadvantages of the roundtable discussions? Well, in terms of advantages, the inspector is in control of timing, so in theory the process should be speeded up. And less formality may make it easier for witnesses and third parties to be involved. The disadvantages are that the instructed barrister is not in control of timing and questioning. There are therefore fewer prompts for the witness, and the parties become reliant on the inspector to pick up all parts of the opposing case that need challenging. As the inspector may not be a landscape or heritage expert, the inspector is not in the same position as the experts to see the weaknesses, hence the emphasis I give to the need to consider rebuttal proofs. And lastly, depending on the witness, it's not necessarily shorter than formal questioning. But just as we thought we were getting used to the changes after Rosewell, there are further changes, and I now hand over to Ed, who is going to talk about the brave new world of remote inquiries.
Thank you, Emily. We may, by the way, go 5 minutes or so beyond 12 o'clock. And some of those key speeding up processes that Emmeline was telling you about that were promoted by Rosewell are on ice effectively, whilst inquiries move into the remote world. And I mentioned in the introduction earlier on that we had 80-something questions in advance of this webinar, and probably half of those were asking how a remote inquiry is going to work. When the country went into lockdown in March, the planning appeal system ground to a halt as all imminent hearings and inquiries were postponed. The planning inspectorate were then faced with the task of working out how to get the wheels turning again. And unlike the court system, the inspectorate were faced with the additional challenge that a public inquiry by definition encompasses public participation. Therefore, a system of remote hearings and inquiries must enable the public to participate, and in that context must be legally sound. And you see here on the screens a chronology. On April the 28th, PINS published that the first fully digital hearing would take place on the 11th of May, that further digital hearings and inquiries would be taking place by June, to be scaled up into July, so that within 6 months, they said, they'd have the capability to conduct fully digital events fairly and robustly across all casework areas and for most cases. And on the 13th of May, the Secretary of State, Robert Jenrick, published a written ministerial statement, and I'll just read you an abridged version of that. The planning system has a vital role to play in enabling the delivery of housing and economic growth that will support the UK's economic recovery. It's important that the system continues to operate effectively while adhering to the government's guidance on social distancing. Moving to digital events and processes will be critical. The government expects events to be taking place virtually by mid-June, other than in exceptional circumstances. Access to planning documents by inspection is not now, by physical inspection, is not now available, and the government considers that online inspection of documents should be the default position across all planning regimes. Where site visits are required or necessary, they should be undertaken in line with the government's guidance on social distancing and safety requirements. And then just back to the chronology, on the 28th of May, PINS responded by publishing their progress report with at least 20 hearings and inquiries due to take place in June, the chosen software being Microsoft Teams. And as to the longer term, PINS said this: we're learning from each event with the aim of making virtual events our standard option for the majority of events in future. Whilst we are progressing virtual events, this is not the end of face-to-face hearings and inquiries. Face-to-face events will continue to be part of our future once the current situation has passed. Next slide, please, Isabella. Now, last week, I had a case management conference with the inspector. Isabella, can you go to the next slide after that, please? Yeah. I had a case management conference with the inspector for a virtual inquiry to take place across 2 weeks in July. And I'll draw out for you some of the practical arrangements which were set out, which reflect, I think, broadly how PINS are approaching remote inquiries. Firstly, the software is Microsoft Teams, and the host is PINS. So far as documents are concerned, documents to be a single PDF, indexed, paginated, and available online. In terms of the inquiry day, that's to be shorter than it would be in a face-to-face inquiry. So 3 1.5-hour sessions in the day with no less than 30-minute breaks between sessions. So my inquiry in July, our sitting times are to be 9:30 to 11, 11:30 to 1, and 2 to 3:30. What had originally been earmarked for roundtable sessions have reverted to more conventional examination in chief and cross-examination. So it looks as if PINs, in some inquiries at least, are favouring the conventional approach to receiving evidence at a remote inquiry, where a few months ago they might have preferred a roundtable discussion. Now that may not be universal, and it may change, and it probably depends on how many participants there are in respect of the particular issue at the particular inquiry, because a roundtable discussion may be more difficult to manage remotely the more participants there are. The result of all this is going to be a shorter inquiry day, but probably also an extended inquiry duration, also to allow for almost inevitable technical glitches. And finally, the question of public participation, finally on this practical arrangements, and Nicola from Horsham asks the very important question, how will the public participate? And that is the question which has been at the forefront of the transition to remote inquiries. Fundamentally, the notification letters to those who've made representations either at the application stage or during the appeal process will identify how those members of the public can observe and participate and how they can access the documents electronically. It is essential that the public are not prohibited from playing their part in what is, after all, a public inquiry. Isabella, can you go back to the previous slide, please? So some useful principles to bear in mind if you're due to give evidence at a remote inquiry, and how should you adapt? Well, first, liaise in advance about scheduling, about special arrangements and protocols and documents. Second, understand the technology. Make sure you test it properly in advance. Third, make sure you can be seen and heard. So, for example, ensure that you're well lit by natural or artificial light. Ensure that the background to where you're sitting is appropriate. Avoid personal or distracting items, so that if you're in inquiry, for example, about Tottenham Hotspur football ground, you probably wouldn't want to have your signed Arsenal shirt on the wall behind you. Close the door to the room in which you're appearing. Ensure that you're an appropriate distance from the screen so that ideally your head and upper body are visible, and maintain eye contact with the camera. Fourth, know how to handle the documents. Make sure you can find them at speed and that you're familiar with the referencing system. Fifth, make the best use of written argument. So as far as possible, don't leave your written evidence, i.e. your proofs, in need of clarification and amplification. And just pausing there, consider whether rebuttals may become more common in remote inquiries to reduce the extent to which, in examination in chief, you would need to be commenting on the other side's evidence. Sixth, be prepared and succinct and brief. That doesn't mean leaving out anything that you consider to be relevant, but prepare even more meticulously than you usually would. And be prepared for the fact that remotely conducted proceedings are almost certainly going to be more taxing than conventional proceedings. So don't be shy to ask for breaks if you feel you need one. Seventh on our list, avoid over-speaking, especially as there may be a slight delay between the video image and the voice being heard. And be aware that gaps between speakers will probably be more common So again, don't feel like it's your job to fill the pause. Finally, on this list, maintain confidentiality. So make sure you clear your table and the shelves behind you of anything, for example, which might relate to other cases. Now, the Planning Inspectorate have issued written guidance for a case management conference etiquette, very similar themes, but one that they have stressed is not talking over people in a remote environment. And PIN's put that very bluntly indeed in this etiquette document, when they said talking over people is rude in any situation. It's pretty blunt there. As to how to give answers to questions in a remote environment, subject to the principles we just set out, the 18 do's and don'ts that we discussed earlier apply in the same way. So as long as you're familiar with the technology, you'll convey your evidence well if you follow those suggestions that we made. So Joanne at Ashford has asked, how do you foresee PINs dealing with cross-examination at a remote inquiry? And so pulling together some of the points we've just been making, the key elements for PIN's approach to cross-examination are short sessions with plenty of breaks, electronic bundles, and in all likelihood a more interventionist approach by inspectors in ensuring that questions are short and relevant and that answers don't ramble. We had questions from both Angela and Matthew at Horsham, who asked the same question in advance of this webinar, and that gives rise to this slide. That question was an excellent one, which is, how should the advocate communicate with the witness, his or her witness, during the evidence? Now, usually, of course, if the advocate is listening to the other side's landscape evidence, for example, you'd have your own landscape witness sitting next to you so that you can communicate easily about the evidence you're listening to. So the answer to that, really, in a remote environment, falls into 4 parts. Well, first of all, a purder point, which is that purder applies in the usual way, so that an advocate can't discuss the case with his own witness between the close of examination in chief and the end of the witness's evidence. Second, although there's a side chat facility available on Microsoft Teams, that should not be used for these purposes. And the reason for that is that PINs are the event host. And therefore, if you were passing comments back and forth with your witness on the Teams chat facility, there would be confidentiality issues because PINs as the host would retain those conversations. So third, the most likely means, therefore, to communicate with your witness during the proceedings, unsatisfactory as it might sound at the moment, is going to be by WhatsApp, and inquiry teams are likely to be operating a group chat facility during the inquiry. That seems to me to be the principal downside, really, of cross-examining or listening to evidence remotely, is that slightly unsatisfactory way in which you have to communicate with your own team. Fourth, the witness should expect to be asked at the outset of their own evidence by their advocate or by the inspector to confirm that such a communication facility, WhatsApp for example, is either switched off or disabled. So, in answer to a number of questions sent to us asking what will be different about remote inquiries, hopefully you've now got a better feel for how they're likely to work. And the way that a remote inquiry works will inevitably develop and probably improve. It's not the finished article, but hopefully what you have now at the end of this webinar is some insight into how remote inquiries are working at the moment. So we've not seen the end, though, of face-to-face inquiries, but the pandemic has quickly ushered in a new way of conducting planning inquiries. And as advocates or witnesses, whether we like the new normal or not, remote inquiries are almost certainly here to stay. So that brings us to the end of chapter 6. I'm sorry we've overrun a little bit. Just before I go to a couple of housekeeping matters to finish with. Emmeline, was there anything that came in during the Q&A that we can answer very, very quickly, given that we've overrun already?
Just very, very quickly, there was a question from Michael Burton. Are you bound by the same protocols when being cross-examined at informal hearings? Michael, I think it's unlikely you will be cross-examined at an informal hearing anyway, but in terms of your duty as an expert, you are bound by your professional obligations in any type of planning appeal if you are giving evidence as an expert.
Thank you. Two final pieces of housekeeping. First of all, there's a continuing programme of webinars being presented by colleagues here at Cornerstone. And if you go to the Cornerstone website, you'll find a regularly updated list of forthcoming webinars. Second, you'll be sent a short survey, I think, in due course. Do feel free, please, to give any feedback, and do suggest, importantly, suggest any topics that you would be keen to see added to our webinar diary. But I hope this morning that you found that useful in the world of change that we're now in. So thank you very much for joining us, and have a good day.